Hey folks, how are you? This is Ron Barriere and I'm here with Tiffany Bentley. Tiffany and I are partners at Burns and Levinson. Burns and Levinson is a mid to large market law firm located in Boston, Massachusetts. We also have satellite offices in Hingham, where I am right now, Wellesley, Providence, Rhode Island. I have been practicing law for about 20 years. Tiffany, why don't you tell us a little bit about yourself?
Sure. Thanks, Ron. As Ron mentioned, I'm Tiffany Bentley. I'm a partner at Burns and Levinson in the private client group. I've been with the firm actually for my entire adult life. I started here as a legal assistant when I got out of college. I left for a few years to go to law school and came right back and made it up to partnership. My practice focuses on divorce litigation as well as estate and trust litigation, which is will disputes, trust disputes, guardianships. Essentially anything that you can fight about in the probate and family court falls within my practice.
And similarly to Tiffany, I've handled virtually all types of cases in the probate and family court as well: divorce, custody, post-divorce matters, guardianships, conservatorships, and a dabble in probate litigation as well. So, in my career, I've tried over 50 divorce law cases. I have either defended or taken hundreds of depositions, and in my practice and in my career, I've had plenty of opportunity to make observations about what constitutes a good witness, and more problematically, what constitutes a bad witness. So Tiffany and I were going to give you folks kind of an overview of depositions, deposition practice, and also at the end, we're going to present you with some tips that we have learned in our careers and that we impart with our clients in order to make them more effective witnesses and be able to handle the scrutiny of cross-examination during depositions a little bit better than most folks. So Tiffany, why don't you tell us a little bit about what depositions are in general?
Happy to do that. And just 2 points before I do that. One is that we are here through a webinar series sponsored by the Divorce Law Monitor blog, but essentially everything that Ron and I will say today has application beyond the realm of family law. So whether it's a deposition in a divorce case, or if it's in a will and trust matter, or even in a business dispute, we think that these tips would be helpful to folks preparing to be a witness. When it comes to being a witness, this can also equally apply to depositions as well as ultimate trial testimony. So we are focusing on depositions. I'm about to explain exactly what that means, but the same tips could be helpful to you in preparing if your case unfortunately does go all the way to trial to be decided by a judge. So what is a deposition? A deposition is a discovery tool. Discovery is the phase of a litigation case where the opposing parties get to discover all of the bits of information that the other side or that third parties may have that's relevant to the case. A deposition in particular is a series of questions and answers taken orally in the presence of a court reporter who will swear in the witness so that the witness is testifying under oath, and the court reporter will then be recording everything that anybody in the room says. The lawyer asking the questions, the witness answering the questions, any lawyers making objections, any extraneous comments that may come in from anybody else who may be in the room. So although it may feel very informal at times, because a deposition is most typically taken in the lawyer's office who's asking the questions. Although these days it's most often being taken just like this over Zoom, which can feel even more informal, as I'd be sitting here in my bedroom asking questions of somebody in their own home office or their own home bedroom. It's important to remember that it is being recorded, that a written transcript will be produced, that it could become part of the record in the trial of your case. Your words can be used to impeach you at trial. And so it's important to take it very seriously, to prepare well, and to do everything you can to best preserve and present your case ultimately for the judge. So with that in mind, we want to make sure that you are best prepared as possible to sit for your deposition and to present yourself. We have actually, Ron, several years ago, put together some written pointers that were published on the Divorce Law Monitor blog, and we will put a link to that blog in the chat function of the Zoom so that you can access that now or later. But for now, I'll turn things over to Ron, and he'll start giving some of those helpful rules and pointers on how best to prepare yourself for deposition.
Yeah, so and I do want to circle back to one point that you made, Tiffany, which can't really be understated, which is the importance of preparation and getting comfortable with the deposition process even before your deposition begins. So these rules that we're about to impart on you are really tips that we have worked out over years of preparing clients in anticipation of their deposition testimony. So we've learned these tricks and we teach these tricks to clients. But I will tell you in my practice, and Tiffany, I would like you to speak on this as well as to your practice. I oftentimes will want to do a dry run with clients and actually have them sit down and have the feeling of being interrogated in a deposition-like setting. I will often bring clients to my office, sit in a conference room and say, okay, this is what it's kind of going to be like. Imagine there's a stenographer sitting over there, and the stenographer's going to have a little computer type thing in front of her, and she's going to be typing away frantically and watching your mouth. And sometimes she's going to interject and ask you clarifying questions about your testimony. And then I will actually even, put a bottle of water and a box of tissues and then lay out some documents in front of the clients so they get a feeling. And I find that in that kind of environment, even if it's just a mock deposition, people tend to get a little more comfortable with the idea of what it is they're going to be going through, because these mechanical things can often be a shock to them the first time they're deposed. Now, have you found success doing something similar as well?
I fully agree with that, Ron. And that's one of the benefits of working in a firm and a group like ours, is that I find that it's even most effective if I bring a client in to do that dry run, to not have me asking the questions, but to have you or somebody else from our group who's a stranger to the case come in and start doing it, just so that it feels more adversarial to the client, as opposed to having me, who has the relationship with them, asking the questions.
Yeah, I think that's a great idea. And it's, I think what we're trying to impart here by giving you folks this general overview is that, to circle back again to something that Tiffany said in her introduction, that, it appears informal, but it's very important. Whatever it is that you say during this deposition is going to be reduced to a writing. And that's actually one of the tips that we're going to be talking about, the importance of remembering this transcript. Again, there's that stenographer there who's going to be typing in her little computer thing or his little computer thing in order to record every word that's uttered, including words that you might wish you hadn't uttered. So it's very important that you're mindful of the import of it, even though it may appear to be somewhat casual and informal, given the fact that you're in an office setting. So the first tip that I always like to impart to my clients is rule number one, and it is the most important rule of all, which is tell the truth. Now, this may seem obvious, but the truth in its simplest form is what you should always be striving for. The first thing I like about the truth is that it's easy to remember. That may sound glib, but the reality is that when people tell lies, they tend to insert extraneous details. They tend to inflame. They tend to complicate things. If you tell the truth in the simplest, clearest term possible, it comes off as credible. Oftentimes, lawyers who've taken hundreds of depositions, who've seen hundreds of witnesses testify, we can kind of sniff out who's phony baloney and who isn't. So, one of the things that I always tell my clients is tell the truth, even if it hurts you. Oftentimes, we have a tendency to try to avoid negative facts as people. We often try to, shade or hide things that we don't want to admit about our own behavior. But you want to resist that temptation. Tell the truth, even if it's hurt you. You've hired a great lawyer like Tiffany Bentley, because Tiffany, even if there's a bad fact, she knows how to deal with the bad fact in the furtherance of your litigation. She knows how to deal with it. Don't try to hide it, and certainly don't lie about it. You will get caught.
Just as a sub point to telling the truth, tell the truth consistently. And what I mean by that is a deposition is not usually the first discovery tool that happens in a case. Typically, a deposition is happening as the case gets closer toward ultimately a trial, so that people can nail down testimony and properly prepare for trial. And so it's likely that by the time you've gotten to a deposition, your story has been told before, whether it's by an affidavit that you've submitted to the court in support of a motion for temporary orders or something similar, whether it's written answers answers to interrogatories, which is another discovery device. So as you're preparing for your deposition and as you're preparing to tell the truth, make sure that you're reviewing your story as it's been told in the past so that you can make sure that your deposition testimony is consistent with what you've said either under oath or otherwise leading up to that point.
Yeah, exactly. Credibility is built over time. And particularly when you get to the point of trial, oftentimes, to Tiffany's point, we've heard these facts as lawyers and also judges. We've heard these facts a number of times, and the more consistent they are, the more credible they are. And the more credible they are, the more credible you are. And that puts you in the best standing if, God forbid, the case goes all the way to the end and the judge needs to fashion a judgment. So the next tip I want to impart is keep calm. Right? That kind of circles back to the importance of preparation. All of us tend to do better when we've done something before. So, again, in my practice and in Tiffany's practice, we're big believers in the concept of a trial run for a deposition. But even if you're not afforded that opportunity to have a trial run with your attorney, you want to keep calm and you want to keep poised. Lawyers have a job to do, and sometimes that job is to ask you questions that you don't necessarily want to answer. But he or she is doing his or her job. So it's very important that even if a deposition feels somewhat adversarial, or if the questioner is bringing you into territory you don't necessarily want to venture in, you maintain your poise and your sense of decorum. Because again, you don't want to have to be chastised about your behavior in a transcript, which will possibly show up and even likely show up in front of a judge someday. So
if you can find your blood, sorry, Ron, I didn't mean to interrupt,
no,
but
absolutely.
just as a related tip, if you can feel your blood pressure rising, if the lawyer is starting to get under your skin a little bit, ask for a break. You're entitled to take a break. You're entitled to leave the room. You're entitled to talk to your lawyer. The rule is that you can't take a break if there's a question pending. So answer the question that's out there and then just say, I need a 5-minute break. You don't have to explain why. You don't have to explain what you're going to do. Just ask for a break.
Yep. And actually, that's a tip that we're going to be exploring further later on, where we're talking about the importance of using the lawyer. You're paying us for a reason. Trust our advice. And also don't be afraid to go get our advice even during an event, including such as during a deposition. But again, to Tiffany's point, you got to answer the question that's pending before you call a timeout. The next thing is take your time. Okay. And I don't mean take your time in terms of, try to talk as slowly as possible. That's not going to engender a spirit of cooperation with your questioner, and it's certainly not going to put you in good stead with anybody in the room. But what I do mean is take your time and really process the question that's being asked and answer it in the simplest and easiest way you possibly can. You want to strive for accuracy and simplicity in all of your answers. You want to try to avoid embellishment or unnecessary exposition. Just really listen to the question that's being asked and answer it. This will also serve your lawyer in good stead, because I can tell you in my practice, oftentimes someone will ask a question that I will think is objectionable. And I want my client to process the information just as I'm processing the information, so that I have enough time to object and protect my client, and maybe even preclude my client from answering an unnecessarily adversarial question. But I need the time to do that. And my client can help me in that regard in terms of taking time. Now, Tiffany, do you find that this is one of the harder things for clients to understand what we mean by taking your time and answering questions?
I think it is hard. And so as a lawyer sitting in the room, sometimes I will make an objection to a question that, I don't know, may or may not really be objectionable, just to try to slow things down a little bit. Because what I don't want to see happen, and what it's hard to avoid, is having your client be lulled into a casual conversation with the opposing lawyer, starting to feel that comfort level and feel like we're just two people here having a conversation. It's not. That lawyer is trying to get at points that are going to help him prove his case. He's not your friend, and we don't want you to have a conversation with him. We want to listen to the question, think about it for a second, answer only that question.
Yeah, and I think that's a good illustration of something that both you and I mentioned at the outset. It underscores it nicely, which is that while it appears to be somewhat informal, it's not informal. And also, I think Tiffany's last point underscores something else that we need to be very explicit about. Lawyers ask questions for a living, right? You wouldn't challenge a college basketball player to a game of one-on-one and think you're going to win. Why? Because they play basketball all the time. Well, Tiffany and I ask questions all the time. This is what we do. This is what we've been trained to do. And this is what we've been doing quite successfully for a number of years. So we know what we're doing. And most lawyers who are taking depositions know what they're doing too. Don't sit there and think that you're going to be able to outsmart a lawyer. It's a mistake. Take your time, take a breath, really understand the specific question that's being asked, answer it simply and easily, and then move on to the next question. Again, the next tip kind of piggybacks nicely on that point, which is remember the transcript. Every single thing that happens in the course of a deposition, unless it's a comment that's taken off the record, and we can talk about that in a moment, every single thing that happens during a deposition is being recorded by the aforementioned stenographer. So it's very important to be mindful that certain traits like charm and wit and kind of, enthusiasm, those things don't necessarily get reflected in a transcript. What gets reflected in a transcript are simply, black letters on a white page. So be mindful about things like sarcasm or things like irony, because that stuff doesn't necessarily translate to the page. It usually doesn't translate to the page. So be careful about being cavalier with, being glib or short with your questioner, because those things tend to bite you in the behind later on when the transcript is issued. Politeness. Be polite. That goes back to the point about being calm, but it bears repeating. Again, there's an adversarial nature of all litigation, and the deposition is no exception. In fact, it's one of the exacerbating events that can increase the acrimony in litigation. But don't lose your cool. Behave like an adult and keep your calm. Be polite. Be courteous, and be mindful again of the transcript. It may be very unfortunate that people lose their cool during depositions, but don't be one of those people that loses his or her cool in the course of your deposition.
Right, and that's even the case. This is not my style nor Ron's, but there are lawyers out there who are going to intentionally try to make you feel demeaned. They're going to talk down to you. They're going to make you feel they're doing this to try to get a rise out of you, to try to argue with you. Don't buy into it. Stay polite, stay calm.
Yep. The next point is, sometimes as a strategy, a lawyer will ask you a question that may be difficult to understand. My rule of thumb in depositions is my rule of thumb in life. Don't ever answer a question if you don't understand what the question is. It's okay to say, I don't understand what you're asking me. I don't understand. Don't fall into the temptation, again, of feeling the informality of the environment and try to help out your questioner. If your questioner asks a question that doesn't make sense, the likeliest event is your attorney is going to object and say, I object. I don't understand that question. I can't imagine my client does either. But try not to help out your questioner by trying to answer the question you think they are trying to ask. Listen to the actual question being asked, and again, answer it in simple and clear terms.
And that also includes a lot of deposition takers will, as the deposition continues, they'll start a question by repeating or recharacterizing something that you've said previously. If a lawyer starts a question with, you testified blah, 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 and you don't agree that that's what you said, say that. Say, well, I don't think that that's what I said, but go on to answer.
I 100% agree, because essentially, remember, the lawyer is asking a question because he or she generally believes they already know the answer, right? They're not necessarily fishing for new information. That is part of deposition practice, but it's actually not as large a part as you might imagine. Generally speaking, when I ask a question of someone, I already kind of know what the answer is, and I just want to get their answer in writing, again, to Tiffany's point, so that I can preserve it in the record for later use. So, be mindful of that, and try not to overthink these things. Listen to the literal question being asked and answer the literal question being asked. Also to that point, If you don't know, don't guess. Feel free to say, I don't know, and I don't remember. These are two of the four what I call magic answers. And to Tiffany's point, years ago, I drafted this memorandum, and one of the hallmarks of this memorandum that we've been circulating around our office for years is this concept of magic answers. And there are four of them. Yes, no, I don't know, and I don't remember. And if you can answer a question honestly in one of those four fashions, you should do so without explanation, without apology. Because again, those questions push back on the questioner, or excuse me, those answers push back on the questioner. Let the questioner do the work. You shouldn't have to do the work. You should hear the question and answer it in as simple a fashion as possible. It's okay not to remember something. It's okay not to know something. Don't guess, don't speculate, don't make stuff up. Be simple, be clear.
And that includes, you may be asked a question that refers to a document, right? To something that you've signed in the past, or something that you've seen in the past, or something that you produced in discovery. If you're asked a question about a document and you don't have a specific memory of the exact words on that document, and the document is not shown to you and placed right in front of you, you don't answer that question. The answer is, I would have to see the document that you're referring to in order to accurately answer that question.
And it's okay to say, may I see it? And if the questioner says, no, you may not, your lawyer is generally speaking not going to allow you to speculate as to the contents of a document that's generally not in front of you. So again, don't try to make it up. Don't try to guess. It's okay to say, I don't remember. That's a perfectly valid answer, so long as it's truthful. Back to the importance of simplicity. Don't volunteer information, okay? Again, the environment may appear to be informal, but your answers are being recorded. So be mindful of that, and don't go telling whole, long, twisted stories. This is a mistake. You're not trying to make friends with your lawyer, or with the lawyer who's asking you questions, excuse me, the questioner. You're not trying to convince that person of anything. That person is not going to be convinced of anything. So all you want to do is answer the question in as simple a form as possible. If there is more to the story to tell than the question allows you to impart, tell your lawyer will be able to ask you questions that enable you to get that information out. But the time to do it is not when you're being questioned by an adversarial attorney.
And if you need to think about the answer to a question, let your thought process be internal and not verbal. It's sometimes tempting to verbalize, to fill the silence with what your thought process is. So to put that into example, if the question is, when did your mother pass away? You might not right away think of the year that your mother passed away, but you may go through this thought process. Well, I know that my mother died 2 years before my father, and I know that my father died in 2019, so my mother must have died in 2017. Do that inside of your head, and then just say, my mother died in 2017.
Yeah, I mean, to emphasize a point that I made earlier, as Tiffany was doing that, I just came up with 5 more questions to ask. Not just about the deceased mother, the circumstances of the deceased mother's death, the father's death, the circumstances of the father's death. I came up with questions about their estate plans. This is natural for us. We take words that you say, and then we formulate additional questions to ask based upon the information that you give. If you simply said, I don't remember when my mother died, that's a perfectly acceptable answer. It's perfectly okay to say that. The lawyer asking you questions will follow up with several more questions, but you never know what information they're really looking for. Let them ask the question. You give them as simple and truthful a response as you can. They'll do the work. Use your attorney. All right, we talked about this earlier. We get paid good money for a good reason. We know what we're doing. Okay, so if you're asked something, you don't like the way the deposition's going, you want a snack, you want to go to the ladies' room, you want to get a glass of water, your blood sugar is low, your blood pressure is high, it's okay to say, can I have a break and speak with my attorney? We're there for a reason. Generally speaking, I would never allow my client to be deposed without me present, ever. Nobody ever asks my client a question unless I'm right there to defend him or her. So one of the things that happens many times during a deposition is you're asked a question that you may not want to answer right away. Do your best to answer it as simply as you can. take a break and say, may I confer with my attorney? May I use the ladies' room? May I use the men's room? May I get a drink of water? May I get a snack? Call time out. Take your lawyer outside and have a conversation. You know, again, to Tiffany's point, we don't want to be speculating. We don't want to be guessing out loud. You can use the opportunity to take some time with your lawyer and make them earn their money to help you through this process. Also, be on the lookout, to something that we talked about earlier is the fear of negative facts. I want to emphasize this again. We all know nobody's perfect, okay? Especially in divorce cases, everyone thinks that the other side is worse than they are, right? We all have our own internal narratives where we're the hero of our own story. But the reality is all of us have made mistakes. It's okay to do that. Just make sure that you have given your attorney enough information to be prepared for those questions as they come up. In a deposition, I can tell you it happens almost every time somebody asks a question that they already know the answer to, and I didn't know about it first. That's because my client didn't tell me. I wish they had. In almost every opportunity, I pull my client aside and say, boy, I wish you told me about that. I could have dealt with it this way. Okay, now that we know about it, this is where I think Tiffany is going to go with her questioning, or this is where I think this lawyer is going to go with her questioning. Be mindful of it. Think it through. Use your lawyer.
And on the same theme of nobody's perfect, we've talked about the transcript several times. After the deposition is concluded, a week or so later, there will be this written transcript produced, and you will have the opportunity to review it. And sometimes the court reporter is not perfect. Sometimes he or she will have made errors in transcription. Sometimes your testimony will not have been perfect. You may have said an incorrect name or something similar. You have the opportunity to review the transcript and within 30 days make corrections on what's called an errata sheet. That doesn't mean you can whole scale change your answers, but you shouldn't have to because you've been telling the truth anyway. That was the first rule that we went over. But you do have the opportunity to make these more minor corrections and make sure that the record is fully accurate after the deposition's concluded.
Yeah. And again, what I always recommend that my clients do when they receive that transcript is I first, will generally send it to them and give them some instruction about, review the transcript. And I tell them to read it, just read it like it's the world's least attractive novel that you're reading, and just read it from front to back, right? So that you get a sense of, the not only your performance, but also what it is that the other side may be looking for. And then I ask them generally to confer with me about any corrections that they have about the transcript, but also, their impressions of not only their performance, but where the questioner was going and larger themes that have emerged through the deposition process. We as lawyers, part of our job is to create a narrative for our clients, a narrative that we intend to carry through trial. And sometimes it takes a deposition for the other side's intended narrative to reveal itself. So if you see it, make sure that you let your lawyer know. Sometimes it happens even during the deposition process, and if you feel like you get a sense of where the other lawyer is going, again, when you use your lawyer and take that time out, you tell your lawyer, all right, he's going to ask me about this. He's going here. He's going about my mother's death and how much money I got out of her estate. If you see it coming, you let us know and we can prepare for it.
And we've been talking a lot about preparing and making sure that you're fully prepared for a deposition. Your preparation is likely going to include reviewing some documents, reviewing old emails, things like that, reviewing pleadings from your case. Don't bring any of that to the deposition with you. Bring nothing but yourself to the deposition, whether it's in a lawyer's office or whether it's by Zoom and you're in your own home office or wherever it is that you may be. You will be asked about anything that's in front of you. So leave it all aside. If you want to review notes during the break, do it somewhere else outside the presence of counsel. Just don't have anything there with you at the deposition table.
Yeah. And also, in your lead up, in the lead up to your deposition, don't ever hesitate to ask your lawyer for his or her advice about anything. I'm a big believer, and I tell my kids this, there's no such thing as a stupid question. There's no such thing as a stupid question. I can tell you, I've been doing this for 20 years. And the answer that the question that I'm asked more than any other, and the question that I've answered more than any other is, what do I wear? Or, do I need to wear a blazer? Is it okay if I wear business casual? I really like jeans. Is it okay if I wear a pair of jeans to the deposition? That's an important question because it's about your comfort level. Feel free to ask us anything. You're paying us for a reason. We know what we're talking about. And you got to listen to that advice. You know, I tell people all the time, if you're not going to listen to my advice, you might as well just throw your money on the floor and light it on fire. Well, that's because I get paid to give advice. I give good advice, and so does Tiffany. We know what we're doing. Don't be afraid to ask us anything, because our job is to help you through this very difficult time in your life, this very adversarial process.
Right. And on the topic of what should we wear to the deposition, keeping in mind that these days pants are optional for a lot of us as we sit here on Zoom. It's fine. Same goes for your deposition, but make sure you turn your video off before you stand up and ask us how we know that.
Right. Well, you know, Tiffany, it's a funny observation that you made, but I suppose, you know, one of the places we should probably wrap up with is the change in deposition practice by Zoom. So I will tell you, I've only had occasion to observe and defend depositions by Zoom. I haven't yet taken one. Can you tell me a little bit about what your feelings are about the Zoom revolution and its impact on deposition practice?
Sure. So I've done several in the past couple of weeks. I resisted it at the beginning of the pandemic. I felt like this wasn't going to last as long as it had. I was sort of delusional about all of that. But the time has come. We couldn't postpone things any longer. So we have had several Zoom depositions, and they've gone better than expected. This is a procedure that people are getting more and more comfortable with. The difficult part has to do with exhibits. It has to do with if you want to show a witness a document and you want to ask them questions about that document, that's a little more cumbersome over Zoom. So there's two options to make that happen. One is that you can have the document put up on the screen. The court reporters have different technology to help with that, or there's the simple share screen function in Zoom. But it's hard to do that because then the deponent's not holding the document themselves. They can't flip through it. They have to rely on you, the questioner, who's in control of the screen, to scroll through it and let them read it. The other option is that you can compile exhibits in advance and send them over to counsel or send them directly to the deponent, whatever it is that you work out. I tend to like that better because I like everybody to have these pieces of paper that they can refer to and be looking at. The downside to it is that you're giving away some of your strategy in advance, right? So you may not want the other side to know what documents you'll be asking them about in advance of the deposition.
Yeah.
And you can do the honor system and say, I'm delivering this to your office, but I trust you won't open the envelope until we get to the deposition and we'll go through things one by one. But you know, who knows how that really works. So the depositions go okay. Exhibits are a little difficult.
I was going to say, you know, with regard to the, you know, the mechanical difficulties associated with document production incident to a deposition, it almost gives the deponent an additional advantage in order to at least be able to know in some fashion where the questioner may be going vis-a-vis the documents. I can tell you from a mechanical standpoint, defending a Zoom deposition, you know, it just required me to make arrangements with the client about timeouts. You know, when you say, I need to speak with my lawyer for a minute, what we're going to do is you have to remember to mute, hit the mute button, hit the video off button. I'm going to be right next to my phone. And unfortunately, I think a lot of our viewers heard my phone ring during this presentation, for which I apologize. But at that time, call me on the phone and we'll hash it out on the phone. We'll just put the video on mute and we'll put the image on silent as well. All right. So with that, I think that we've covered the topic pretty handily. I don't know if any of our viewers have any questions that they wish to ask us by way of the chat feature on Zoom. But if so, now would be a good time to do it before we wrap up.
So we can give folks a few minutes to put questions into the chat or the Q&A. I have a question for you, Ron.
Sure.
You know, it's not every case, and you know, you said you haven't had occasion to take a deposition in the past 10 months since the pandemic hit. So we don't use depositions in all cases.
Right.
When do you determine to take a deposition, and what are you hoping to accomplish with it?
Yeah, so I mean, I think that's an excellent question. I mean, I will tell you that you know, the discovery phase is the phase of the litigation where you're seeking information on behalf of your client through the discovery process. But, you know, candidly, I personally don't often use depositions much for that purpose. I'm more interested in, to your point earlier, committing the deponent to a story, getting them to commit their version of the events to writing so that I can utilize it later, usually to cross-examine them about it. I also am using it really to kind of get a cut of their jib, to get a sense of the kind of witness they may be, what topics are sensitive, what topics I can utilize in order to rattle them at trial. I tend not to try to rattle witnesses too much at deposition because, you know, frankly, it's a lot of strum and thurm without any substance. I would rather get them to lose their composure at trial rather than in a deposition. More to the point, it's so that I can have that transcript to refer to earlier in order to compare inconsistencies with respect to their testimony over time, through affidavits, through pleadings that were filed with the court, and then compare those representations with the representations they made under the scrutiny of cross-examination in a deposition.
Great. I agree with all of that fully. We did have a question come up in the chat while you were talking. The question is, do both lawyers have to agree to the same Zoom deposition format regarding exhibits? That is, send in advance versus display on the screen. The answer is no. The lawyer who's taking the deposition is in charge of how they're going to conduct their deposition. So if I'm taking the deposition, I get to choose whether I submit the exhibits in paper copy in advance or whether I choose to just put them up on my screen. And the opposite, if I'm observing or defending a deposition that another lawyer is taking, that lawyer gets to decide how they're going to present their exhibits.
Yeah, and I think that's you know, the point in specific yields a point in general, which is that the questioner really controls the operation of the deposition. So you want to be mindful of that. I mean, essentially, the deponent is the star of the show, but he or she is really a guest of the questioner. So the person who's asking the questions, the person who scheduled the deposition, is in charge. And that includes things like stipulations. Usually at the outset, there's going to be a conversation between counsel that happens in the presence of the deponent, and it happens on the record, which is, what is your preference with respect to objections and stipulations? Most lawyers will say something like the usual stipulations will apply. What that means is that all objections, except as to matters about attorney-client privilege or criminal matters, including people's right against self-incrimination, or matters that have bearing on attorney-client privilege relationships. Everything else is kind of fair game at a deposition. So, you know, even questions that may seem irrelevant are not really objectionable during depositions for the most part.
That's a really good point, Ron. The scope of discovery, including a deposition, is much broader than the scope of what is ultimately admissible at trial. So
Right.
they'll be able to ask questions about things that you don't think you should have to answer. You probably have to answer them anyway in terms of the deposition.
Yeah. I mean, the classic example is, what is your favorite color? That may not seem relevant to you. It's likely not relevant to the litigation, but you don't know where the questioner is going. The questioner may have some evidence that you're not aware of. So you need to be mindful of that. And again, just to answer the questions that are presented to you in the simplest and easiest form possible. And if your lawyer thinks you're being unfairly targeted or mistreated during the pendency of the deposition, it's incumbent on that attorney to object on your behalf. All right, it seems like we don't have any more questions, and I think our time is coming to a close. So Tiffany, I just want to thank you for your time and for your preparation in this. This is, it's been great to hear another smart lawyer telling me about her practice with regard to depositions, and especially in this Zoom era. So thank you very much for your time.
Likewise, what a pleasure. Thank you. And let's do it again.
Yes, absolutely. And folks, if you have any additional questions, or if you'd like to know more about Burns and Levinson or Tiffany or me, just feel free to reach out to us. Our contact information is readily available on the Divorce Law Monitor and on the Burns and Levinson webpage. So thank you folks very much for your time, and everybody have a happy new year and be safe in this pandemic. Okay, take care.
Thanks,
folks.
everyone.